will come to order. This House will come to order. House will come to order. Members will take their seats. My colleagues, we have a former member of this House on the floor. He has since moved on to greater things on the DOT board. Former chairman of Banks and Banking, Greg Morris. Let's give Greg show our appreciation to Greg. Chairman Stevens is recognized for a motion.
Thank you, Mr. Speaker. I move this House agree to the Senate substitute to House Bill 557 as amended by this House.
Clerk will read the caption.
House Bill 557 by Representative Stevens, the 164th, to be entitled an act to amend Chapter 34 of Title 43 of the Official Code of Georgia annotated relating to physicians, assistants, and others, so as to authorize physicians to delegate the authority to advanced practice registered nurses.
Chairman Stevens is recognized to explain the Senate substitute and the House amendment.
Thank you, Mr. Speaker. As you might recall, Georgia is the only state in the country, except for Oklahoma, that doesn't allow the nurse practitioners to write Class II narcotic prescriptions. This was amended over in the House. We passed it out of here overwhelmingly, of course. They passed it out of the Senate and made some very good changes. They did strip out the stimulants that was in the bill, and for those 18 years or older, they will be able to prescribe some narcotics for those patients that are in emergency need. They'll be able to do a 5-day supply. And the Senate also added a section that I agree. They added 2 sections to the bill that says that hospitals that are permanently closed, and I'm going to agree to this, has their covenants not to compete if they're closed will be non-existent at that point, and that I agree to. We're working on some language on the second part, which is Section C. This says no restrictive covenant imposed or enforced by the hospital or the hospital system merged can be or acquired by a third party that such third party reduces the compensation of a physician. We're working on language on this as if you'll send it back to the Senate to make sure that we don't have some unintended consequences for this. So I would ask that you agree to the Senate substitute as amended by the House.
Gentlemen, yield to the will. No questions. Is there any objection to the adoption of the House amendment? Chair hears none, and the House amendment is adopted. On the gentleman's motion that the House agree to the Senate substitute to House Bill 557 as amended by the House. All those in favor will vote yes. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? All members voted. Well, that's the Spring Olympics, I think. There's what we're talking about. The Spring Olympics. All members voted. If so, the clerk will lock the machines. On the gentleman's motion, the yeas are 173, the nays are 2, and the House has agreed to the Senate substitute to House Bill 557 as amended by the House. Chairman Hitchens is recognized for a motion.
I move that the House agree to the Senate substitute for House Bill 35.
Chairman Hitchens moves the House agree to the Senate substitute to House Bill 35. Clerk will read the caption.
House Bill 35 by Representative Hitchens, the 161st and others, being entitled an act to amend Chapter 2, Title 52 of the Official Code of Georgia annotated relating to the Georgia Ports Authority so as to provide for powers of the authority.
Chairman Hitchens is recognized to explain the Senate substitute.
As many of you recollect, I was here about 3 weeks ago with House Bill 35, which extended the police authority for the Georgia Port Authority Police 1 mile from the radius of the existing boundaries. What the amendment over in the Senate did was it deleted the boundaries for the inland ports. Many of you know we have 2 inland ports now, one in Cordele and one in North Georgia, and we never ever considered those to be part of the port when we constructed this bill, so we agreed to it. The Ports Authority agrees to it.
Gentleman has no questions.
Thank you.
He's yielded the well. On the gentleman's motion that the House agree to the Senate substitute to House Bill 35, all those in favor will vote yes. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? All members voted. If so, the clerk will lock the machines. On the gentleman's motion, the yeas are 172, the nays are 0, and the House has agreed to the Senate substitute to House Bill 35. Representative Houston Gaines is recognized for a motion.
Thank you, Mr. Speaker. I move that the House insist on its position on Senate Bill 63.
Mr. Clerk, will you read the caption?
Senate Bill 63 by Senator Roberts of the 29th and others to be titled an act to amend Chapter 6 and Title 17 of the Official Code of Georgia annotated relating to bond and recognizances so as to provide for the setting of bond and the schedules of bail.
Representative Gaines is recognized to explain the motion.
Thank you, Mr. Speaker. Working with the Senate, we're working through some additional language. This was the bill we discussed at length this morning, and so we're going to insist, hope the House will join us in insisting on our position on Senate Bill 63.
Gentleman, yield for a question.
I will.
Whip Park to your left has a question.
Thank you, Mr. Speaker. Chairman Gaines, is it not true that if you opposed Senate Bill 63, that would make nonviolent offenses bail restricted, that you should vote no to this motion?
Thank you, Whip Park, for your question. I think voting yes to get us to the posture of insisting on the House position is the right vote, so I'd ask for the body's favorable consideration. Mr. Speaker, I'll yield the well and ask for the House to insist on its position on Senate Bill 63.
Gentleman's yielded the well. Representative Gaines has moved that the House insist on its position on SB 63. Insist. Is there objection? Chair hears none, and the House has insisted on its position on SB 63. Representative Leverett is recognized for a motion. Gentleman's recognized. How many do you have? 80.
Thank you, Mr. Speaker. I move that the House agree to the Senate substitute for House Bill 80.
Mr. Clerk, will you read the caption?
House Bill 80 by Representative Leverett of the 123rd and Oliver of the 82nd to be entitled an act to amend Article 1 of Chapter 14 and Title 24 of the official code of Georgia annotated relating to general provisions regarding proof generally so as to enact the Uniform Unsworn Declarations Act.
Representative Leverett is recognized to explain the Senate substitute.
Thank you, Mr. Speaker. Majority Caucus Chairman Williamson pointed out to me it was on the board. I just hadn't seen it, so my apologies. This is the bill that allows a written declaration that does not have to be notarized to be introduced into evidence. It was sponsored or proposed by the Atlanta International Arbitration Society. If you recall, we approved that bill, sent it back. On the way over, we caught a cleanup issue with regard to the form of the signature block, where it actually had to say that you understood you were signing it under penalty of perjury. Because we required that it's only effective if it's signed outside the United States. We also have an affirmation that you understand you affirm that you're signing outside the United States. So it was good changes, and we would ask that you approve that substitute.
The gentleman has no questions.
Thank you, Mr. Speaker. I yield the well. Ask your favorable consideration of the Senate substitute to House Bill 80.
Gentleman yielded the well. On the gentleman's motion that the House agree to the Senate substitute to HB 80, all those in favor will vote yes. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? All members voted. If so, the clerk will lock the machines. On the gentleman's motion, the yeas are 175, the nays 0. And this House has agreed to the Senate substitute to House Bill 80. I think I'm all right. Chairman Irwin is recognized for a motion.
Thank you, Mr. Speaker. I move that the House agree to the Senate substitute for HB 87.
Mr. Clerk, will you read the caption?
House Bill number 87 by Representative Irwin of the 32nd and others to be entitled an act to amend Chapter 2 of Title 20 of the official code of Georgia annotated relating to elementary and secondary education so as to revise and repeal certain provisions for alternative charter schools.
Chairman Irwin is recognized to explain the Senate substitute to House Bill 87.
Thank you, Mr. Speaker. And colleagues, again, this is our completion school bill that we passed unanimously out of this House earlier this year, or this session. That the Senate changes are that we've given a definition to the Department of Defense Youth Challenge Academy within the bill. Those are those students that are in those different academies. We also added language for grandfathering the existing kids. Remember, we have 3 of these programs, Mountain Ed, Foothills, and Coastal Plains across the state. We have grandfathered those children that are already enrolled and in those schools. And then the last thing here was if a student lives very close to a school outside of their zone, so in the zone right next to them, remember they're zoned by what we call RESAs, so there are 2 RESAs put together, that is counties of schools. If they are much closer to that other zoned school, they're allowed to go there then. So, and it would make sense if they're 50 miles away from the zone they're in, but they're only 1 mile away from the other zone, We're allowing them to cross over to that zone and go through there. Colleagues, what I ask of you is your favorable consideration of these subs. This is a good program to help our students that are non-traditional and at risk of dropping out.
Gentleman has no questions.
Well, I'd ask for your favor and thank you very much, and looking forward to hopefully all green.
All those in favor will vote yes. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? All members voted. I believe you may be Irish. If so, the clerk will lock the machines. On the gentleman's motion, the yeas are 175, the nays 0, and the House has agreed to the Senate substitute to House Bill 87. Chairman Corbett is recognized for a motion.
Thank you, Mr. Speaker. I make a motion that the House agree to the Senate substitute to House Bill 120.
Mr. Clerk, will you read the caption?
House Bill 120 by Representative Corbett of the 174th and others to be titled an act to amend Code Section 4564 of the Official Code of Georgia annotated relating to limited driving permits for certain offenders so as to provide for standards for issuances of such permits.
Chairman Corbett is recognized to explain the motion to agree to the Senate substitute.
Thank you, Mr. Speaker. What we're doing here was a House Bill 120. This is a combination of a bill that passed here, House Bill 120, and House Bill 167 were combined into one bill, and the only changes other than that they made in the Senate was to add some language where the limited driving permit could be revoked for a limited reason. This is all the only change we made in the bill from when it left the House. I appreciate everybody's favorable consideration.
You have no questions. The gentleman's yielded the well. On the gentleman's motion that the House agree to the Senate substitute to House Bill 120, all those in favor will vote yes. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? All members voted. If so, the clerk will lock the machines. On the gentleman's motion, the yeas are 171, the nays are 1, and the House has agreed to the Senate substitute to House Bill 120. Representative Reeves is recognized for a motion.
Thank you, Mr. Speaker. I move to agree to the Senate substitute for House Bill 182.
Clerk will read the caption.
House Bill 182 by Representative Reeves, the 99th and others to be entitled an act to amend Article 1 of Chapter 2 of Title 44 of the Official Code of Georgia annotated relating to recording of deeds and other real property transactions so as to revise provisions for curing defective deeds and other instruments.
Representative Reeves is recognized to explain this motion.
Thank you, Mr. Speaker. House colleagues, I present to you House Bill 182 as amended by the Senate. Section 1 of this bill was passed overwhelmingly by the House. It's a State Bar of Georgia real property law section amendment based on in response to a court decision to keep clear title and security interests safe. Section 2 and following was the product of a lot of House work. Even though it is a Senate amendment, it was formerly House Bill 292, which passed the House Judiciary Committee, but shortly before crossover day. It is also a Title 44 provision regarding mortgages, title insurance, things like that. So would ask your favorable consideration of House Bill 182 as amended. Thank you. I yield
Gentleman,
well.
will he yield for a question?
I will yield for a question, Mr. Speaker.
Well, the question waived, so you're good. The gentleman is yielded the well.
Thank you.
On the gentleman's motion that the House agree to the Senate substitute to House Bill 182, all those in favor will vote yes, those opposed will vote no, and the clerk will unlock the machines. Have all members voted? All members voted. If so, the clerk will lock the machines. On the gentleman's motion, the yeas are 166, the nays are 9, and the House has agreed to the Senate substitute to House Bill 182. Chairman Saines is recognized for a motion.
Thank you, Mr. Speaker. I move to agree to the Senate substitute of House Bill 188.
Mr. Clerk, will you read the caption?
House Bill 188 by Representative Saines, the 180th and others to be entitled an act to amend Article 2, Chapter 6 and Title 5 of the Official Code of Georgia Annotated relating to appellate practice so as to revise the name of the Sexual Offender Registration Review Board.
Chairman Saines is recognized to explain his motion.
Thank you, Mr. Speaker. The Senate substitute simply clarifies the scope of what we've done in Merriam's Law, which is formerly the Dangerous Sexual Predator Prevention Act, which passed unanimously in this chamber and in the Senate. It limits the scope of the mandatory ankle monitoring to individuals who adhere to that twice adjudicated felony level sex offense to parallel what we're going to do that lifetime concurrent probationary sentence. Thank you, Mr. Speaker.
You do have a question.
I'll yield for a question.
Representative Ramon in the center aisle to your left.
Thank you. Does the gentleman yield?
I do.
Just really quickly, I want to confirm the LC number. Which one are you going off of?
I have House Bill 188, SCSFA.
Thank you.
Thank you.
No further questions.
Thank you.
Gentleman's yielded the well. On the gentleman's motion that the House agree to the Senate substitute to House Bill 188. Yes. All those in favor will vote yes. Those opposed will vote no. And the clerk will unlock the machines. Have all members voted? All members voted. If so, the clerk will lock the machines. On the gentleman's motion, the yeas are 172, the nays are 0, and the House has agreed to the Senate substitute to House Bill 188. Representative Leverett is recognized for a motion.
Thank you, Mr. Speaker. I move that the House agree to the Senate substitute to House Bill 227.
Mr. Clerk, will you read the caption?
House Bill 227 by Representative Leverett of the 123rd and others to be entitled an act to amend Title 16 of the Official Code of Georgia Annotated relating to crimes and offenses so as to provide for the offense of criminal interference with critical infrastructure.
Representative Leverett is recognized to explain his motion.
Thank you, Mr. Speaker. Ladies and gentlemen, this was the critical infrastructure bill that created the enhanced penalties for damage to critical infrastructure like utilities and power substations, as well as electronic interference with financial data and other kinds of systems of that nature. In the Senate, they added the word railroads to vital public service. We felt it was already included in the terms, but they wanted to be there expressly, so we agreed. And then we added a cross-reference on the last page to the use of the word vital public service in the domestic terrorism statute. So I'd ask your favorable consideration of those changes. We think it improves the bill.
You have a question. Gentleman yield?
Yes, I yield.
Representative Moore to your left has a question.
Does the gentleman yield?
I yield, yes, ma'am.
Thank you, Speaker. Thank you. Does this include the covered bridge? God knows we need that.
I'm
in
not
Marietta?
sure if it would, well, it does include transportation systems. I suppose that would be a matter of interpretation. But for your sake, ma'am, I'll certainly hope it does, and we'll see if we can make it happen.
That is Cobb County. It's not in my district, but I have a lot of friends that live over there, and that bridge is getting hit every month at hundreds of thousands of dollars every year, probably millions by now.
Well, depending upon its location and its use and the frequency of use it gets, it could be considered under here because it would be included within a transportation system.
It's clearly marked. Tells you how high. They still keep going in there and knocking it down and blocking the residents into their neighborhoods.
Well,
Can't
it's
get
my
out.
hope that maybe this could be used to deter the next person if they can catch somebody.
Okay,
Good
thank
answer.
you.
Gentleman has no further questions.
Thank you, Mr. Speaker. I ask your favorable consideration or agreeing to the Senate substitute. Thank you.
The gentleman has yielded the well. On the gentleman's motion that the House agree to the Senate substitute to House Bill 227, all those in favor will vote yes. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? All members voted. If so, the clerk will lock the machines. On the gentleman's motion, the yeas are 169, the nays are 0, and the House has agreed to the Senate substitute to House Bill 227. Chair Lady Lynn Smith is recognized for a motion.
Thank you, Mr. Speaker and members of the House. Good afternoon. I bring to you this afternoon a request to agree to the Senate substitute to House Bill 243.
Mr. Clerk, will you read the caption?
House Bill 243 by Representative Smith of the 70th and others to be entitled an act to amend Code Section 1562 of the official code of Georgia annotated relating the number of judges of superior courts so as to provide for an 8th judge.
Chair Lady Smith is recognized to explain her motion.
Thank you, Mr. Speaker. The reason for the dates changes is due to a timing issue with the appropriations bill. That's it, simply.
You have no questions.
Thank you, Mr. Speaker. I yield the well.
The lady has yielded the well. On the lady's motion that the House agree to the Senate substitute to House Bill 243, all those in favor will vote yes, those opposed will vote no, and the clerk will unlock the machines. Have all members voted? All members voted. If so, the clerk will lock the machines. On the lady's motion, the yeas are 163, the nays are 0, and the House has agreed to the Senate substitute to House Bill 243. Chairman Corbett is recognized for a motion.
Thank you, Mr. Speaker. I make a motion that the House agree to the Senate substitute to House Bill 268.
Mr. Clerk, will you read the caption?
House Bill 268 by Representative Corbett of the 174th and others to be entitled an act to amend Chapter 6A, Title 35 of the official code of Georgia annotated relating to Criminal Justice Coordinating Council so as to provide for the establishment of a grant program to support local law enforcement agencies.
Chairman Corbett is recognized to explain the Senate substitute.
Thank you, Mr. Speaker. The changes in the bill in the Senate on line 81, we added a sunset, which I agree with. Lines 91 and 93, we swapped the Attorney General and a member of State Patrol from 4 to 5 because it had those out of place. That was a error we made drafting it originally. And then on line 108, now the governor will appoint ones listed in 5 through 10 instead of 4 through 10. And that's the only changes in the bill, Mr. Speaker. Members, I appreciate your favorable consideration.
I have a question.
Yes, sir.
You didn't really mean the House made a mistake in drafting.
I misspoke, Mr. Speaker. I believe they inadvertently messed up over in the when they drafted the bill. It was not the House that did that.
Thank you for clarifying that. The gentleman's yielded the well. On the gentleman's motion, the House agreed to the Senate substitute to House Bill 268. All those in favor will vote yes. Those opposed will vote no. And the clerk will unlock the machines. Have all members voted? All members voted. If so, the clerk will lock the machines. On the gentleman's motion, the yeas are 158, the nays are 5, and the House has agreed to the Senate substitute to House Bill 268. Representative Ballard is recognized for a motion.
Thank you, Mr. Speaker. I move that the House agree to the Senate substitute to HB 538.
Clerk will read the caption.
House Bill 538 by Representative Ballard of the 147th to be entitled an act to amend Chapter 2 entitled 20, the Official Code of Georgia annotated relating to elementary and secondary education so as to provide for the Georgia Early Literacy Act.
Representative Ballard is recognized to explain the Senate substitute.
Okay. The language of the substitute of the amendment originated with HB 1357, which passed the House unanimously in 2022 and was added at the request of the PSC. It deals with procedures to consider teacher certification for teachers who move here who are licensed in other states, and I ask for your favorable consideration.
You have no questions.
Thank you. I yield the well.
Ladies yielded the well. On the ladies' motion that the House agree to the Senate substitute to HB 538, all those in favor will vote yes, those opposed will vote no, and the clerk will unlock the machines. Have all members voted? If so, the clerk will lock the machines. On the ladies' motion, the yeas are 164, the nays 0, and the House has agreed to the Senate substitute to House Bill 538. Chairman Lumsden is recognized for a motion.
Mr. Speaker, members of the House, I move that the House agree to the Senate substitute for House Bill 541.
Mr. Clerk, will you read the caption?
House Bill 541 by Representative Lumsden of the 12th and others to be entitled an act to amend Article 1 of Chapter 6 of Title 40 of the Official Code of Georgia annotated relating to general provisions relative to uniform rules of the road so as to provide for a proper procedure for passing a postal service vehicle.
Chairman Lumsden is recognized to explain the Senate substitute.
Senate substitute for House Bill 541 simply combines two bills that were passed out of this House, both of which deal with the same subject matter, appropriate procedure for when you approach a postal service vehicle, a sanitation vehicle, or a vehicle on the shoulder of the road using flashing emergency lights, provides for the proper procedure to move over, pass at a slower speed, or be prepared to stop depending upon conditions. That's the bill, Mr. Speaker. I'd appreciate your favorable consideration.
The gentleman has no question as he's yielded the well. On the gentleman's motion that the House agree to the Senate substitute to House Bill 541. All those in favor will vote yes. Those opposed will vote no. And the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines. On the gentleman's motion, the yeas are 168, the nays are 0, and the House has agreed to the Senate substitute to House Bill 541. The Dean of this House, Chairman Gerald Green, is recognized for a motion.
Thank you, Mr. Speaker and members of the House. I move that the House agree to the Senate substitute to House Resolution 157.
Mr. Clerk, will you read the caption?
House Resolution 157 by Representative Green and the 154th and others, authorizing the lease of certain state-owned property located in Appling County and authorizing the conveyance of certain state-owned property located in Bacon County.
Chairman Green is recognized to explain the Senate substitute.
Thank you, Mr. Speaker. This is under our conveyances. We had passed, and since the Senate, they added one more, and it was for Muskogee County. And I have talked to the members of the delegation, and they are in agreement with what the Senate has done. Mr. Speaker, if there's no questions, I yield the well.
Gentleman had no questions. He's yielded the well. On the gentleman's motion that the House agree to the Senate substitute to House Resolution 157, all those in favor will vote yes. Those opposed will vote no. And the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines. On the gentleman's motion, the yeas are 165, the nays are 0, and the House has agreed to the Senate substitute to House Resolution 157. Chairman Green is recognized for a motion.
Thank you, Mr. Speaker. Mr. Speaker and members of the House, I move that the House agree to Senate substitute to House Resolution 158.
Mr. Clerk, will you read the caption?
House Resolution 158 by Representative Green and the 154th, authorizing the grant of non-exclusive easements for the construction, installation, operation, and maintenance of facilities, utilities, roads, and ingresses and egresses.
Chairman Green is recognized to explain the Senate substitute.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, the Senate added a couple of more that were not ready when the State Properties was meeting, and they finished up putting those together, and they were added in the Senate. They deal with Bacon County, Chattahoochee County, Gwinnett County, and Wheeler County. Mr. Speaker, if there's no questions, I yield the well.
On the gentleman's motion that the House agree to the Senate substitute to House Bill 158, House Resolution, 158, House Resolution. All those in favor will vote yes. Those opposed will vote no. And the clerk will unlock the machines. Have all members voted? All members voted. If so, the clerk will lock the machines. On the gentleman's motion, the yeas are 166, the nays are 2, and the House has agreed to the Senate substitute to House Resolution 158. Floor Leader McDonald is recognized for a motion.
Mr. Speaker, I make a motion that the House agree to Senate substitute to House Bill 163.
Mr. Clerk, will you read the caption?
House Bill 163 by Representative McDonald, the 26th, and others, to be entitled an act to amend Chapter 10 of Title 49 of the Official Code of Georgia annotated relating to Georgia Board of Health Care Workforce, so as to provide for student loan repayment for medical examiners employed by the Division of Forensic Sciences.
Representative McDonald is recognized to explain the Senate substitute.
Thank you, Mr. Speaker, ladies and gentlemen of the House. There's only a minor change. This is the GBI loan repayment program that's being managed by the Georgia Student Finance. This is the only change that was made is that it was to begin January of 2024. The change is now any current GBI medical examiner can be a part of this loan repayment. Since this bill started, we were at 9 when it started. We've had 1 to leave, so we're at 8 for medical examiners in the whole state of Georgia. But we do have 3 that have guaranteed to come when this bill passes. And for those from Central Georgia and South Georgia, 1 has agreed to go to Macon, Georgia, to be a medical examiner, which is great for our state. So, Mr. Speaker, if there are no questions, I yield the well.
You have a question to your left. Representative Jasmine Clark has a question to your left.
Thank you, Mr. Speaker. Does the gentleman yield?
Yes.
Is the Georgia Student Finance Authority ready to implement this immediately? I know in committee we talked about them needing time to get the program running. So are they ready to start right now?
Yes, they're going to be ready. It's in the FY 23-24 budget, so they're ready to begin the program.
Thank you.
You have no further questions.
Thank you, Mr. Speaker. I yield well.
The gentleman has yielded the well. On the gentleman's motion that the House agree to the Senate substitute to House Bill 163. All those in favor will vote yes. Those opposed will vote no. And the clerk will unlock the machines. Have all members voted? If so, the clerk will lock the machines. On the gentleman's motion, the yeas are 168, the nays are 1, and the House has agreed to the Senate substitute to House Bill 163. Representative Victor Anderson is recognized for a motion.
Thank you, Mr. Speaker. I move that the House agree to the Senate substitute to House Bill 121.
Mr. Clerk, will you read the caption?
House Bill 121 by Representative Anderson of the 10th and others, to be entitled an act to amend Article 1 of Chapter 7 of Title 52 of the Official Code of Georgia annotated relating to registration, operation, sale of watercraft generally.
The gentleman is recognized to explain the Senate substitute.
Thank you, Mr. Speaker. House Bill 121 is the wake boat bill that passed out of this chamber a couple of months ago. In the Senate substitute, we've done a couple of things. First of all, we've removed the lines that refer to 400 feet from shore to shore. We've also added a provision that allows for, with proper licensing for side-by-side UTVs, to get a special license plate and be eligible to drive on county roads and cross state and municipal roads only. If there's no questions, I'll yield the will.
Well, you have no questions.
Thank you.
The gentleman has yielded the well. On the gentleman's motion that the House agree to the Senate substitute to House Bill 121, all those in favor will vote yes. Those opposed will vote no. And the clerk will unlock the machines. Have all members voted? All members voted. If so, the clerk will lock the machines. On the gentleman's motion, the yeas are 165, the nays are 2, and the House has agreed to the Senate substitute to House Bill 121. Chairman Carson is recognized for a motion.
Thank you, Mr. Speaker. I move this House disagree to the Senate amendment on Senate Bill 240.
Thank you. Mr. Clerk, will you read the caption?
Senate Bill 240 by Senator Walker, the 20th, and others to be entitled an act to amend Title 47 of the official code of Georgia Annotated relating to retirement and pensions so as to revise the minimum and maximum allowed benefit multiplier for current and future retirees.
Chairman Carson is recognized to explain his disagreement to the Senate amendment.
Folks, this is Senate Bill 240. The Senate adds some new language that's not been through committee on our side, and we're just in a disagree posture. Just ask for the House's favorable consideration.
On the gentleman's motion that the House disagree to the Senate amendment, is there objection? Chair hears none, and the House has disagreed to the Senate amendment to Senate Bill 240. Mr. Clerk, will you read the caption to House Resolution 651? Members, this is the House supplemental calendar that we've adopted for today. H.R. 651.
House Resolution 651 by Representative Knight of the 134th and others, a resolution urging the Georgia congressional delegation to assist in finding reasonable solutions to protect North Atlantic right whales and Georgia's coast culture and economy. This bill having been referred to the Committee on Rules, that committee recommends that this resolution be adopted.
Chairman Knight is recognized to present the bill.
Thank you, Mr. Speaker. Members, this is an issue that is an urging resolution, as you just heard the clerk, but I want to explain the issue to you. First of all, from a conservation point of view, as a sportsman, the chairman of the Sportsman's Caucus, many of you have seen me for years up in the well. I'm very much a conservationist and stand very firm with making sure we protect our resources, both on land and in the sea and water. And what this resolution deals with is proposed rules that are coming out of National Marine Fisheries Service in regards to strikes, vessel strikes on the Atlantic right whale, and we know those are endangered species. And again, we in Georgia take our conservation very seriously. Ultimately, what we want to do with this resolution, if you'll look at the end, is to make sure that we're urging Congress to make sure that they are funding and properly trying to fund and find a real solution to make sure that they got funding to make sure we've got a real-time monitoring solution on these right wells. Let me repeat that. We're urging Congress to make sure that they've got the funding to do a real-time monitoring on these right wells so that we know where they are. But as it currently stands right now, there are proposed regulations that are coming out that would impose a vessel strike reduction rule, and that rule would impose, get this, a 10-knot maximum speed for nearly half of the year out to 40 miles offshore. Again, 10 knots maximum speed limit for nearly 6 months out of the year off up to 40 miles offshore. And there are significant problems and concerns here. And quite frankly, it's the unforeseeable, it's human risk. And we know in getting boats that speeds make a difference, and depending on the oceans, the weather. We also know that there will be negative, in fact, I would say detrimental impacts to the Georgia anglers and boaters in the fishing, boating industry. In addition to the economies of the coast, plus the biggest thing, I think one of the biggest things is our ports and all those cargo ships that are coming into Georgia. And we know that the technologies out there through aerial surveillance, acoustic monitoring, satellite tagging, DNA detection technologies, that we can do this in a real-time way. And we know that Congress has authorized the National Marine Fisheries to take these measures, and we just want to make sure that they can design and deploy these real-time monitoring and mitigation program so it does not kill, and I literally say that, the sport fishing industry, our commercial fishing, and our boating industry, in addition to our ports, our cargo, and what's going on the coast of Georgia. So that's what this resolution does, and we want to make sure we're good stewards, but we also want to do it in a way that protects our coast, its resources, and that culture on the coast. If there's any questions, Mr. Speaker, I'll be glad to stand for some.
Okay, you have a whole bunch of questions.
Right.
Let's see. A lot of them from the coast, and I know they know what they speak down there. To your left, Representative Al Williams is recognized for a question.
Thank you, Mr. Speaker. Will the gentleman yield?
To my friend off the coast, I sure will.
First, is it not true that I would like to apologize to a member of the Chatham delegation that I told this resolution had already passed? It's inadvertent on my part.
Well, you're going to help, I hope, make sure we rectify that problem.
Will the gentleman further yield?
Yes, sir.
What effect, based on what you're saying, what effect would this have on the commercial shrimping industry on the coast of Georgia?
That's a great question, Representative. I know that's very dear and to your heart, not only being right there at the heart of what we all enjoy is Georgia seafood and shrimp, not only shrimp, but again, the seafood and the fish off of it. My understanding, again, to the rules, if you've got a vessel that's 35 feet or longer, and during this time, almost 6 month period, if you're outside of Georgia waters, which I think is either 3 or 4 miles, you are restricted by this. And I think it would be very detrimental to our commercial fishing industry, and certainly detrimental to our local folks, especially shrimpers who are already under the gun. Mr. Speaker, I'll take maybe 2 more questions.
Okay, you got it. Let's see. Chairman of Economic Development, Chairman Ron Stevens to your extreme left has a question. The gentleman's recognized.
Thank you, Mr. Speaker. The gentleman yield.
I will to my friend from Savannah.
Is it true, 2 things, that the Georgia Ports Authority has sent letters in requesting they reconsider this action?
That is true.
And isn't it also true that a boat or a ship with all those containers on it at 10 knots can't safely navigate if they've got the tide pushing them in? Is that not true?
Yes, sir. I think you bring up some great points. My understanding is that Quite frankly, there may be ships that are waiting out at sea for weeks or months for a berth to come in, because this would slow down the pilot ships and the captains. Quite frankly, we could see cargo, and again, this is all across the Atlantic seaboard. We could actually see cargo. This would change how cargo imports and exports happen from the state of Georgia. We could see those start pushing to the Gulf Coast or even the West Coast. And if we think we've had supply chain issues in the past, this is likely to exacerbate that to a level that we haven't seen before, and we've seen some bad times. And additionally, it's about $3.8 billion in revenue it could mean to Georgia, and about almost 27,000 jobs due to the import and export and the activity on the ports and the coast. So thank you. You're exactly right. One more question, Mr. Speaker.
Whip Park, right in front of you, has a question. Gentleman's recognized.
Yes, sir.
Thank you, Mr. Speaker. Chairman, I would certainly defer to your expertise and your wisdom when it comes to conservation measures. And of course, without a doubt, I would never question your sincerity. Just to clarify, this resolution would simply urge the Georgia congressional delegation to assist coastal communities by appropriating funds, and does not ask to urge for the repeal or reconsideration of any rule or pending rule. Is that not
Well, I think
true?
that's what we're trying to do. There's a lot of data that was in here, and we believe that marine fisheries didn't take some of that data into account. And what we're hearing from the boating industry, sport fishing industry, maritime industry, is that there are technology out there through real-time technology that we can identify where these wells are, make sure that our boaters, our sport fishers, our commercial fishermen, our cargo ships know where these wells are, avoid them, avoid the strikes, but yet not disrupt and quite frankly, I dare say decimate part of Georgia and its economy, its revenue, and the tradition of sport fishing.
Thank you.
Mr. Speaker, I don't know, one more, I don't know if there's one more maybe, or that's just, Mr. Speaker.
Gentlemen, you have more questions, but if you want to take them.
Jesse.
Chairman Petrie, to your left, has a question.
Yep.
Thank you, Mr. Speaker. Does the gentleman yield?
I sure do.
My friend, I know you know well my commitment to the islands, having been born and raised there. I want to ask you a question. Is it not true that we have a vibrant fishery and we have a great deal of charter fishing well off the coast? 10 knots is 11.5 miles per hour, so the body's aware.
That's correct.
And is it not true that oftentimes people are fishing 30 miles off the coast and everywhere in between?
To my friend off the coast, I know that when I've been offshore off the coast of Georgia, we're out to 40, 50, even 60 miles off till we find blue water. In essence, it would do away with offshore fishing and the charters in the state of Georgia during those times, basically doing away with that profession.
Thank you, Mr. Chairman. That is
Thank
exactly
you.
what I was trying to emphasize. Thank you, sir.
Members, I appreciate it, and I'd urge you to support this resolution. We
Gentleman
can
has
be
one more question. One more question.
One more question.
One more question. Representative Williams, to your left, has a question. You yield? I mean, do you waive or you have a question? She's recognized for a question.
Thank you, Mr. Speaker.
Yeah. Yes, ma'am.
So I'm genuinely confused. My question is, are you're worried about a study or a practice that seeks to protect right whales having a negative impact on the fishing industry? Is that what this is about?
I think the proposed rules that we're seeing that have been proposed under the marine fisheries, national marine fisheries, are rules that, quite frankly, I think fall short of good conservation, because we know that technology, the tools are out there to do real-time, and again, real-time monitoring, okay? But instead, they have chosen to propose rules that would quite frankly, be almost impossible, if not kill every part of the coast by limiting vessels that are 35 feet or longer to 10 knots or less for almost 6 months out of the year. one that will devastate the state of Georgia, its economy, its sport fishing, the boating industry, okay, the commercial fishing industry. But on top of that, as a conservationist, we know the technology is out there to do real-time monitoring, and that's what this resolution is seeking Congress to do, is put the funds, the money in there to do real-time monitoring. You know, I followed OSearch for a while,
Yeah.
and you can get on an app, and they've got tags, and you can see what sharks are around the world. We
So-
can do this with the whales.
Yeah, thank you. So further question, so is the plan that is being proposed that troubles you, who is it being proposed by?
The National Marine Fisheries,
The
out of
National-
NOAA. Yeah, out of NOAA.
Okay, and further question?
Yes, ma'am.
So the money that you're proposing and the technology for actually monitoring and keeping up with right whales during real time, would that go to that same, I mean, if that, I know this is an urging resolution, but would that money go to the same group, and is there any way to?
Yeah, it would. And if you look on line 24, it's a great question. Make sure we clarify this. Congress has already implemented some measures through Section 11303 of the National Defense Authorization Act of 23 that authorizes a pilot program to design and deploy near real-time monitoring and mitigation program for these wells.
Okay.
And what we're doing is urging Congress to continue along that and to fund that measure so that we can get real-time monitoring, meaningful monitoring, and we can also make sure that our coast, our state, are not decimated by this, I would say, not well thought out rule.
Yes, sir. I just hope that whatever we do end up doing does not lead to the extinction of the right whale. Thank you.
No, ma'am, and I want to make sure you're clear on that. There's nobody that wants that. Thank you, Mr. Speaker. I urge you to support this very, very important measure, and so we can keep Georgia on the forefront, both from a conservation perspective and as a growing state supporting a lot of economic jobs.
Gentleman has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the adoption of the resolution? The chair hears none. The report of the committee is agreed to. Shall this resolution now be adopted? All in favor of the adoption of the resolution will vote yes. All those opposed will vote no. And the clerk will unlock the machine. For what purpose does Chairman Collins rise? I know you have some whales up there where you live.
Parliamentary inquiry, Mr. Speaker.
State your inquiry.
Have we ever heard any kind of response back when we send up urgent resolutions to Congress? Do they ever respond back and say, hey, we appreciate you, or we don't like you? Just a curious question. I'm supporting the resolution, by the way, just parliamentary inquiry.
Well, that's a good question. I think they probably read them to an empty house from time to time when we see up there. But it's definitely a good question. And I'm sure the gentleman believes everything he said about the U.S. system in the Senate and the House. Have all members voted? All members voted. If so, the clerk will lock the machine. On the adoption of the resolution, the yeas were 168, the nays 2. The resolution having received the requisite constitutional majority is therefore adopted. Representative Burchett is recognized for a motion. Mr. Whip, you're recognized for a motion. You have a motion? Let's hear it.
Sorry. Getting late.
Hour is late, Mr. Speaker. I motion that we agree to House Bill 611 from the Senate.
The Senate substitute.
Senate substitute.
That's
Senate
the
substitute, yes,
one. Clerk will read the caption.
House Bill 611 by Representative Burchett of the 176 to be entitled an act to amend Part 1 of Article 4, Chapter 12 of Title 45, the official code of Georgia annotated relating to management of budgetary and fiscal affairs so as to provide for the disposition of state funds derived from certain legal judgments or settlements.
Mr. Whip is called multitasking. I think that's what they call it. Chair Burchett is recognized to explain the Senate substitute.
Thank you, Mr. Speaker. House Bill 611 is the bill that we voted on that essentially says this. It says that any monies or funds that come from settlement agreements or judgments that the House and the General Assembly should have the opportunity to appropriate those funds. As with any lawyer's bill, the lawyers over on the other side rearranged the words and didn't change the policy, underlying policy. It's the same bill, same exact bill. The effective date is June 1, and essentially says that any settlement agreement or any proceeds from a settlement shall be appropriated in line with any MOU settlement agreement that is a part of that litigation. We will be bound by those settlement agreements and MOUs. In other words, the money that we receive as a state, we can't just spend however we want to spend. If there's an MOU or a settlement agreement that says opioid mitigation is where we must spend the money, that is where we must spend the money. We can't just spend wherever we like. But it does assert that the General Assembly is the appropriators of the state and that we will have an opportunity to appropriate those funds. And that's for any settlement agreement going forward after June 1. And, Mr. Speaker, that's the crux of the bill.
Gentleman, yield for a question?
I do.
To your left, Representative Lisa Campbell has a question.
Yes, thank you, Mr. Chairman. Do you yield, please?
I do.
I remember discussing this in committee. Could you just clarify what the Senate substitute added or changed?
They didn't change the underlying policy of the bill. The only thing they did was rearrange the wording in the bill. We added judgment to the bill and made sure, for clarity purposes, that June 1 applied to settlements, judgments, and any MOU that is attached. We added the word MOU because these national settlements all have a MOU where the state gets the local jurisdictions, cities, counties to agree to an MOU, and so we thought it was important that we recite that in the bill. So there's no underlying policy change, just addition of words.
Gentleman has no further questions.
Thank you, Mr. Speaker.
Gentleman has yielded the well. On the gentleman's motion that the House agree to the Senate substitute of House Bill 611, all those in favor will vote yes, those opposed will vote no, and the clerk will lock the machines. Have all members voted? Have all members voted? Now that's your speak button, request to speak button there, Representative Williams. You've already spoken. Okay, we got you now. All members voted. If so, the clerk will lock the machines. On the gentleman's motion, the yeas are 171, the nays are 0, and the House has agreed to the Senate substitute to House Bill 611. Chairman Chuck Martin is recognized for a motion.
Thank you, Mr. Speaker. I move that the House disagree to the Senate amendment to the House substitute for Senate Bill 13, that the House disagree.
Mr. Clerk, will you read the caption?
Senate Bill 13 by Senator Albers, the 56 and others to be entitled Act to amend Code Section 913-161, 4414-162, and 4841 of the Official Code of Georgia annotated relating to where and when sales under execution held and change of places of public sales by court order.
Ladies and gentlemen, the Senate added back in some language.
Hold it just a minute there, Mr.
I'm
Chairman.
sorry.
So you're doing, let's see, you have a disagreement here. Yeah, we need you to explain that motion you just made. That's what I need, so I need to know what you're doing. Gentleman's recognized.
Thank you, Mr. Speaker. Apologies for getting ahead of my speaker. Ladies and gentlemen, I just ask that you disagree so we will get in a posture to appoint a conference committee and work this out. The Senate added some things to a good bill we had passed out of here, I think, without a dissenting vote, and we'll work with them if I can get you to concur with me and disagree to the Senate amendment. If there are questions, I'll answer them. Otherwise, I yield the well.
Great job. You have no questions. The gentleman yielded the well. On the gentleman's motion that the House disagree to the Senate amendment to the House sub, is there objection? The chair hears none, and the House has disagreed to the Senate amendment to the House sub to Senate Bill 13. Chairman Blackman is recognized for a motion.
I know. I thought I was one more. Thank you, Mr. Speaker. I move that we agree to the Senate substitute to House Bill 414.
Mr. Clerk, will you read the caption?
House Bill 414 by Representative Blackman and 146 and others be entitled an act to amend Chapter 1 of Title 37 of the Official Code of Georgia annotated relating to governing and regulation of mental health so as to provide for a grant program within the Department of Behavioral Health and Developmental Disabilities.
Chairman is recognized to explain his agreement to the Senate substitute.
Thank you, Mr. Speaker, fellow members. If you recall, House Bill 414 would create a matching grant program to help our military service member veterans and their families access behavioral health services through nonprofit community programs. There are two changes from the Senate. One, and this is agreed upon by both departments, it would move it from the administrative portion from the Department of Behavioral Health to the Department of Veterans Services, and it would also add a transparency piece on lines 53 through 55. Both are agreeable, and I would ask this body's favorable consideration to this Senate substitute.
Gentleman, yield for a question?
I would.
To your right, Chairman Bonner has a question.
Does the gentleman yield?
Yes, sir, Mr. Chairman.
Is it not true that this is a great bill and will benefit more than 700,000 veterans and their families here in the state of Georgia?
I certainly hope the gentleman knows what he speaks. Yes, sir, I would agree with that.
You have no further questions?
I'll yield the well. Thank you, Mr. Speaker. Thank you, fellow members.
Gentleman has yielded the well. On the gentleman's motion that the House agree to the Senate substitute to House Bill 414, all those in favor will vote yes. Those opposed will vote no. And the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines. On the gentleman's motion, the yeas are 169, the nays are 0, and the House has agreed to the Senate substitute to House Bill 414. Chairman Alan Powell is recognized for a motion.
Thank you, Mr. Speaker. I'd like to move for this House to agree to the Senate substitute as amended by the House.
Mr. Clerk, will you read the caption?
House Bill 196 by Representative Powell, the 33rd, and others to be titled an act to amend Article 9 and Chapter 12 of Title 16 of the Official Code of Georgia Annotated relating to access to medical cannabis, so as to provide that the Georgia Access to Medical Cannabis Commission shall be subject to the Administrative Procedures Act.
Please, members, give your attention to the member in the well. Chairman Powell is recognized to explain his motion.
Thank you, Mr. Speaker, and ladies and gentlemen. Y'all may remember on crossover we passed House Bill 196 and we're trying to do a correction to a situation that's existed for 7 years plus. 7 years ago, if you remember, we adopted and accepted the fact that medical grade cannabis oil could be a cure to a lot of the illnesses of the disease, from children to veterans to a number of different diseases. 4 years ago, we had established a commission to move forward, and here we are 4 years later, and it's still not gone forward. There was two, you may remember, that were granted a license before TRO was accepted. You may remember the dialogue of that day, that they were not subject to open records, and because of that fact, that brought on litigation that has tied and embroiled this process. Now, what we passed out of the House we thought was a pretty good bill, but you may remember at that time I spoke on this, that there was a lot of interest on both sides of the House and in the Senate about moving this to a more open process through the Department of Agriculture. The legislation that passed was basically amended, quite frankly, in not so favorable a light over in the Senate committee. Now, what this bill does, and I want to give some thanks. I want to thank Chairman Tyler Paul Smith. I want to thank Chairman Jay Collins. I want to thank the members of the various committees. I want to thank, and most special thanks to Leader Effistration. This bill came back in a totally unworkable fashion from the Senate. And what you've got before us is a new bill that what we've done is gone forward with a lot of the same language that we had, plus some new improvements, in my opinion. Ladies and gentlemen, what this bill does, this abolishes the Cannabis Commission and it transfers its functions to the Agriculture Department, where there's a responsible elected official that can be accountable to the people of this state to administer the program. The Division of Agriculture will be subject to Administrative Procedures and Open Records Act, so there's no secrecy and by any unelected bureaucrat. The appeals and the decisions of the administrative agency will be made, any of these appeals will be made by the statewide business courts. If y'all remember, that came from the bill that we left this House with. Licensees will also be able to have an additional dispensary on location. The dispensary will be able to sell any of its products as well as those other products manufactured by any of the other operations. So then that will be a fully professional operation, that this vital medical oil will be accessible to any and all of these different diseases and ailments. A joint robust oversight committee is established. This is by chairs from the House, the Senate, plus one appointed by the Speaker and one by the Lieutenant Governor to oversee the workings of the Department of Agriculture in this industry. Then we get into the real guts of how this is going to be fixed, ladies and gentlemen. The Agriculture Committee will mediate. We're not allowing them to just give licenses to the 9 who protested, but the Ag Commissioner will mediate with the 9 companies. And if they're acceptable, and if they meet all the credentials and the qualifications, then they might be able to get a license if they then drop that litigation that we had talked about earlier. The Commissioner will also have the discretion, but not an obligation, to issue additional licenses based on that registry that you remember we talked about on crossover day, based on the number of new registrants that go onto this. So we're looking at 15, possibly 20. This vests in the discretion of the Ag Commissioner to allow him and his team of experts to ensure a healthy and a fair market to bring this needed medication to the citizens of Georgia. And last but not least, this added one additional illness, and that was the ulcerated colitis. That, ladies and gentlemen, is what this bill does. If you go through the bill itself, you'll look at a number of the sections that deal wholly with abolishing and transferring this to the Department of Agriculture. With that, Mr. Speaker, I'll be glad to stand for questions.
Gentlemen, you have a couple of questions.
Yes, sir.
To your left, Chairman Werkheiser, recognized for a question.
Yes, sir.
Thanks, sir. You yield?
Yes, sir.
Is it not true that right now we have 35,000 card holders, and the 6 proposed license holders would supply 1.2 million patients, and that you're proposing that we may add 9 more?
I think what the true number, it has dropped off in the registrants have dropped off with expirations. I understand it's down below 30,000 into the 20s.
It's actually grown by 20% in the last 6 months. Is it not true that an administrative law judge of 17 years with a background in healthcare heard every one of the protesters over a 60-day period and issued several hundred pages of unredacted applications and rejected every one of the protests?
If the gentleman so states. I'm not an attorney, but I know that that's what has led to the litigation in these cases.
Speaking of litigation, is it also not true that the Georgia Constitution, Article 3, Section 6, Paragraph 4, prohibits this body from passing legislation to specifically reward individual protesters with licenses? And this would not only not get rid of lawsuits, I can think of at least 6 or 7 more lawsuits that would be brought forth because of those who invested millions of dollars because they thought they had a license are now being told that we're going to not open the process up, but give this to who knows who, a commission that we're now abolishing, that both this chamber, the chamber across the hall, and the governor signed, and that we're basically allowing a couple of individuals to rewrite the law. I just think we are 45 days away from having oil on the shelf, and to bring forth legislation that would put this in jeopardy when we are, in fact, two of our
Is there a question there, Mr.
Yes.
Chairman?
Is it not true that the two Class 1 licenses are producing, and we are 1 lawsuit away in full county for the other 4 to start producing, and we would have the 6 licenses that this body, the body across the hall, and the governor signed?
If the gentleman thinks that's correct, I'm sure that he believes in his heart and soul he's right. But then again, that gentleman represents one of the cannabis operations that has a monopoly in this state today. These are the same arguments that were heard in the House the House Judiciary, non-civil judiciary. Now, as far as the litigation and the constitutional requirements, this legislative body has the ability to change and to correct any of. This body has the ability to pass legislation to correct and to change anything that may have been disparaged or any errors in judgment by previous legislative bodies. Now, the argument was made in the House Judiciary Committee by some of these attorneys representing the two companies that have a virtual monopoly in this state. Now, there's 4 that have not been, that were tentatively awarded, and you have 9. And for the people in the House, that they may remember the arguments, that the 9 that protesters, they protested because of the process of the evaluation, which was not dealt with, and that's the reason it's in litigation today. And this has been tied up, and it has the potential, according to the attorneys on judiciary and to the attorneys that basically spoke during these committee meetings, that this could be tied up for a number of years. And most of us have realized that it is not healthy to have 2 companies to have a virtual monopoly in this state.
Is it not true those 2 large companies that you're referring to testified in committee, both in the House and the Senate, that they wish the other 4 were producing, and the only reason we have a duopoly is because the protesters keep filing additional lawsuits, and if it is the goal of this body and everyone else to get medicine to the patients within 45 days, is it not true we should vote no on this bill? I appreciate your passion. We've been on the opposite side of this for a couple of years. I'm glad we agree on every other issue, and I appreciate your efforts.
Appreciate your zealousness to represent from this floor the interest of the company that's located in your district.
Well, the gentleman will stick to answering the questions very closely. Now, you have a lot of questions here, Mr. Chairman, so we're going to have a couple of more. Representative Stacey Evans is recognized for a question.
Thank you, Mr. Speaker. Does the gentleman yield?
Yes, ma'am.
Mr. Chairman, is it true, I'm looking at the documents here, the bill you're asking us to agree to is 54 pages. Am I right?
There's a second part that's going to be addressed, again, dealing with hemp legislation.
Will you further yield?
Yes, ma'am.
That 54-page bill that we're asked to agree to right now is much different than the 12-page bill that was vetted in committee in the House and voted on by this body on crossover day, true?
That is correct.
Will you further yield?
I certainly will.
Do you share my concern that if we make these changes, which is now going to be the second session that we've made significant changes to this commission, that we really urge anybody who's gone through a competitive bidding process and lost to run to the courthouse and create a bunch of chaos to make us sort of chase our tails around here and keep changing and changing and changing and really take away uncertainty for business and for consumers and most importantly for patients who need this medicine?
As a learned attorney who makes her living serving as an attorney for litigants, I'm sure that you understand that everyone has got a right to file suit if they've been wronged. It was the opinion of these protesters that they had not been done correct, because you may remember the language that we had talked about or that I had spoke from was when the applications were given, you had the commission members that divvied them up, the same application was put forth, but that yet whenever the applications were done, they were graded on a numerical system, so that the same answer, no matter what it might have been, it was given a 1 or a 5. So it was basically a system that was flawed from the beginning. There's where it has brought this forward. And if I may further address, in this bill, over half of the pages deal with just disassembling the commission and then reassembling it under the authority of the Ag Commissioner. The base of the bills continues to be what it was when we passed, with that exception. Then the back, starting on page 40 of this bill, deals with the hemp that Chairman Perkle and Chairman Corbett so diligently dealt with. That starts on page 40 in section 2. Now, that was a consumer bill that I'm going to address, or they will address through questions. But that's to be sure that we don't have adulterated CDB hemp-based products that are being imported to the state, the synthetic grade products, the things that create a more of a health issue to the people of Georgia. So in fact, you have 2 bills that were basically disregarded in the Senate committee at the whim of one of the people that was chairing that meeting. So that's where the limit, you asked about the page numbers, that's where the number of pages come from. Be glad to answer any specific questions, But if what you're saying is, and your original question, is it not right that we're giving someone, we're not saying that the commissioner will give a license. They will then have the opportunity to go through mediation to see if they meet the qualifications, and then he can have the ability to move forward if they so desire.
Will you yield for one final
Yes,
question?
ma'am.
I understand your point about legislation relating to hemp being added, but that still would make this bill that we're asked to vote on today with other than being able to ask you questions, no real debate. We're not allowed to come up and speak. So 38 pages compared to 12 that we passed out of this House on crossover that was subject to the committee process. Am I right that that means that this is 38 pages of legislation that has not gone through the committee process?
This legislation has gone through the process, and we're debating it as a committee of the whole House at this point. I'll be more than glad to go by section for the good lady if she wishes.
Well, I wish we could have a full debate, but unfortunately our House rules don't allow us to do that. But thank you.
If you would prefer, I'll be glad to go section by section through the bill to show you where the number of pages that you're talking about were created.
Let's go.
Gentlemen, you for another question. To your right, Chairman Perkle is recognized for a question.
Yes, sir.
Thank you, Mr. Speaker. Does the gentleman yield?
Yes, sir.
I will not ask you to go through section by section. Is it not true that the part 2 of the amendment is virtually identical to HB 458, the only change being to tighten the guardrails that we've talked about with hemp as it relates to this consumer protection bill?
You're absolutely right.
Could I ask one further question?
Yes, sir.
Is it not true that a recent Journal of American Medical Association study found that 76% of hemp products are inaccurately labeled, and the part 2 of this bill that was passed out of this body 168 to 2 seeks to do two things: provide consumer protections and to make sure that those under 21 do not have the ability to purchase these products.
You're absolutely right, and I thank you for y'all's work on this.
Thank you.
Gentlemen, further yield?
Yes, sir.
Let's see, Representative Shay Roberts to your left out front.
Will the
Recognized for a
gentleman
question.
yield?
Yes, ma'am.
Okay, I was sat through the hearings and I listened to a lot of it. This is a lot different than what was there. I want these people to be able to get the medicine they need. So I just want to be clear. I'm not necessarily opposed to going to the Ag Commission. I always love more transparency in government. But if we do this, is that going to hold up the current people who got the licenses from getting the product out to the people who need it?
No, ma'am. If this bill passes the way it is or in its similar form to this, by abolishing the Cannabis Commission, moving it to the Commissioner of Agriculture and the oversight committees there, then they have a date by May 31st that they've got to enter into mediation with the protesters. If the protesters show good cause that they are under the standards that they're eligible, then they will be allowed to have a license, if and under the condition that they drop any litigation. And that's the determining factor. This goes back to the same argument that was made, that this is going to be tied up for probably a considerable period of time. It's in the Court of Appeals right now, has the potential to go into the Supreme Court.
But I don't know that I feel like this is actually going to get us out of litigation. It may get us back into more litigation, and that's the part that I'm struggling with, I'll be honest.
Well, the language that you had heard from one of the earlier questions was the same language that was used by some of the attorney lobbyists that were representing the two companies that had received, that got out before the TRO was issued. And they used a lot of clever language about how they could sue and such as that. There's nothing that prohibits the General Assembly of Georgia for changing laws to fix litigation, such as at any time through legislative action, this body can add as many more as they wanted to. So there's no litigation to be filed. These were veiled threats, in my opinion, and in the opinion of the Judiciary Committee, because they passed it out pretty handily.
Okay, thank you.
Thank you, ma'am.
Gentlemen, yield. Majority Leader Estration, right in front of you.
Thank you, Mr. Speaker. Gentlemen yield for a series of questions.
Yes, sir.
Probably yes or no questions. So, first of all, as members are concerned about the legislation that's before them, we can actually go through briefly, because as you point out, the whole first part of the bill dealing with the Cannabis Commission and now the Ag Commissioner regulating this, as a lot of pages just related to removing commission and replacing it with the department. Isn't that true?
That is correct.
Isn't it true that the transparency provisions that were in House Bill 196 that this body previously voted on and passed are included in here to provide transparency to this process?
Absolutely.
Isn't it true that the bill here, as we look at section 1.6, would create legislative oversight of this process so that there would be specific legislators who would have the ability to ensure that this new system that would be in place is being handled properly, and that if there are issues that come up, that action can be taken by the General Assembly?
Absolutely correct.
Isn't it true that section 1.8 for the Class 1 licenses and a companion section in 1.9 for the Class 2 licenses would simply allow for the Department of Agriculture to issue licenses consistent with their new oversight of this cannabis process?
Absolutely.
And isn't it true that the only mandate, there was a questioner earlier asked about, it's unconstitutional to mandate the outcome of litigation, that's not what is being done in this bill at all. There is no requirement that licenses be issued to any protesters. Isn't that true?
Absolutely right.
Isn't it true that the only thing required is that the department engage in mediation with those protesters, and that take place by the end of May? So to the gentlelady's concern, that there is an expedited period within which these protests could potentially be resolved.
You're absolutely correct.
Isn't it true that the trigger, what I call the trigger provision that deals with the automatic ability of the department to issue subsequent licenses into the future to ensure that there is not a monopoly by a small number of holders of these licenses, remains in this bill, and that is similar to language that we passed out of this body in House Bill 196 before. Is that correct?
Absolutely.
And the only difference here is an actual increase in the number of patients that would be on the registry. So to the concern that was raised earlier that maybe the license holders could address the need, there would be a greater number of patients needed compared to what we passed on House Bill 196 for additional licenses to be available for issue. Is that true?
You are correct.
And then finally, with respect to the conditions for coverage, only UC, ulcerative colitis, is being added as an additional condition. No other conditions, as maybe have been. So in other words, the only additional condition today is the one that was debated in committee in the House, correct?
That is correct.
Now, part 2 of the bill dealing with hemp, that legislation was carried by Chairman Perkel and previously passed this House overwhelmingly, correct?
Absolutely.
And that includes common sense measures to ensure that ingestible hemp products are properly regulated so that minors don't have access to those products, and so that we have a regulatory structure in place for the reality of these new ingestible hemp products. Is that correct?
Correct.
All right. Thank you, sir.
Thank you, sir.
Gentleman has a couple of questions. Will he yield?
Yes, sir.
Representative Hutchinson, to your right, has a question. Ladies recognized.
Does the gentleman yield?
Yes, ma'am.
Is it not true that this legislation will move the needle forward for all of the patients who have been patiently waiting for medical cannabis for the last 7 years?
Yes, ma'am. You're exactly right, and thank you.
Thank you for bringing this legislation.
To your right, Chairman Newton is recognized for a question.
Thank you, Mr. Speaker. Will the gentleman yield?
Yes, sir.
Thank you, sir, for this legislation. I do want to point out that
as you move it from the Medical Cannabis Commission to the Department of Agriculture, is it correct that there's nothing in this bill that changes the use that's been approved by this body, that rather than recreational, this is really for compassionate medical use, and that's your
You're
goal?
absolutely right. This sticks into the medical category. There's no recreational drugs allowed in this.
Thank you, sir.
Gentlemen yield.
Yes, sir. Maybe one more question.
Okay.
Thank you.
Whip Park is recognized for a question.
Thank you, Mr. Chairman. So in conclusion, Chairman Powell, is it not true that this bill would expand access to THC oil by expanding the number of licenses while putting additional restrictions on hemp products? Is how I'm reading it.
It will expand the production of medical cannabis facilities and stop the duopoly that exists right now. On the hemp part of the bill that was sponsored by Chairman Perkle, this puts guardrails into the hemp, the CDB type things, the Delta things, and those type of products in the gummies, to be sure that any of these products that are sent into Georgia, whether it be from wherever, overseas or the West Coast or wherever, that they're not synthetic and that they meet certain health standards.
Thank you.
Thank you.
You have one more, and we'll have them all done since you're just about there. This is our last question.
Mr. Speaker, I'll do one more and then I'll finish it up.
Representative Willis is recognized for a question. Representative Inga Willis.
Thank you, Mr. Speaker.
To
Does
your
the
right.
gentleman yield?
Yes, ma'am.
Isn't it true that this legislation not only addresses the existing duopoly and current licensure and allows for more transparency in process?
You're absolutely right.
Does the gentleman further yield?
Yes, ma'am.
Isn't it true that proper regulation of specified hemp products serves to protect the consumers of Georgia?
You're absolutely right.
And would the gentleman graciously yield one more time?
I certainly will.
Isn't it true that on the other side of this debate that has lasted for years, there will be thousands of Georgians that will receive medicine that they desperately need to improve their quality of life, especially our seniors?
You're absolutely right, and that's what is most important.
Thank you for bringing this bill.
And thank you for the questions. Mr. Speaker, if I might sum this up to the ladies and gentlemen, you know, the question it came because of the number of volume of pages in this. Well, the first 40 pages of this deals with the cannabis, and most of those deal with disassembling the commission and moving it to the Department of Agriculture. Certain language was put in there to be sure that we're not saying that we're rewarding anybody because they have filed a lawsuit, but they have to go through the mediation process. We have put a lot of efforts into this, and I would encourage you to move forward, especially the language that Chairman Perkle and his folks had put together about the other protections under the CDB-based products. And that, Mr. Speaker, is a bill, and I'll be more than glad to support all of your help on this bill, and let's move it back to the Senate.
The gentleman has yielded the well. Is there any objection to the adoption of the House amendment? The chair hears none. The House amendment is adopted. On the gentleman's motion that the House agree to the Senate substitute to House Bill 196 as amended by the House. All those in favor will vote yes. Those opposed will vote no. And the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines. On the gentleman's motion, the yeas are 154, the nays 13. The House has agreed to the Senate substitute to House Bill 196 as amended by the House. Floor Leader Gamble is recognized for a motion.
Thank you, Mr. Speaker. I move that we disagree to the Senate amendment to Senate Bill 246.
Clerk will read the caption.
Senate Bill 246 by Senator Hodges III and others to be entitled an act to amend Chapter 10 of Title 49 of the Official Code of Georgia annotated relating to Georgia Board of Health Care Workforce.
Representative Gamble is recognized to explain the Senate amendment.
The Senate amendment is a technical issue that we are working to fix, and disagreeing to this amendment will allow us the ability to do that. Happy to answer any questions.
You have no questions. On the gentleman's motion that the House disagree to the Senate amendment to the House sub, is there any objection? The chair hears none, and the House has disagreed to the Senate amendment to SB 246. We're going back on to the rules calendar. Mr. Clerk. Will you read the caption to Senate Bill 133?
Senate Bill 133 by Senator Strickland of the 17th and others to be entitled an act to amend Chapter 11 of Title 15 of the Official Code of Georgia annotated relating to the Juvenile Code so as to create a uniform process to assume custody of children as a result of disposition orders. This bill having referred to the Committee on Juvenile Justice, that committee recommends that this bill do pass by Rules Committee substitute.
Representative Rob Leverett is recognized to present the bill.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, it's my pleasure to present you Senate Bill 133. This is a bill that attempts to provide a statutory framework for juvenile court judges when they are considering certain cases that might involve placement of a child with Department of Family and Children Services or just removal of a child. It helps to understand there are basically three different sort of kinds of proceedings you can have in juvenile court. There's dependency, delinquency, and child in need of services. You know, of course, dependency is where a child is found to be dependent, where that is the I'm sure I have the definition here. The child has been abused or neglected, is in need of protection of the court, or has been placed for care or adoption. Then you have delinquency, which is kind of the version of criminal court for juvenile court. And then child in need of services, which was a proceeding that was developed several years ago that's basically intended to try to avoid removal of children from a home when they are engaging in certain behaviors which makes them difficult for parents to manage. They don't attend school, they're runaway, they're loitering, it even says to patronizing a bar. So generally in delinquency and CHINs, they call child in need of services, it's not contemplated that children will be removed from the home. That's more of a dependency determination. And there's a fairly detailed set of statutes in the juvenile code that deal with the procedures that a court has to go through to make sure that it protects the parents' constitutional rights, the due process rights of the parents and the child, and just to afford all parties notice. This bill is attempting to ensure that if a court does make a non-emergency placement, and that's a very important distinction, this is not for an emergency case, but if a court is starting to make a non-emergency placement in a child in need of services case or a delinquency case, that it go through certain steps. And these are fairly common sense, but they are, the law currently doesn't have a set statutory process for the courts to go through. So this just makes sure the court does things like check on what might else be available for placement, find out what services the child has had in the past, find out if there are any records relating to the child that would be useful to review. And it does that both in delinquency and the so-called CHINs cases. So we believe this would provide greater uniformity. It ensures the protection of the rights of all parties and ensures that there's notice provided. And it would, we believe ultimately it provides for a better placement and protects the rights of the child and makes sure that the child's getting the best placement and the best services that's possible, which is ultimately the goal of any juvenile court proceeding, really. So there is a letter, I think, that was handed out a few days ago when we were considering bringing up the bill, and then it didn't come up We placed it out again today. The Office of Child Advocate does support the bill for the reasons I've mentioned, just ensuring a process so we give courts a checklist to go through to make sure that the rights of all parties are being protected. So we would urge your favorable consideration of the bill, and Mr. Speaker, I'll yield for any questions.
You do have some questions. To your left, Representative Oliver has a question. To your extreme left. Ladies recognized.
Does the gentleman yield?
I yield, yes, ma'am.
Isn't it true, sir, that there are 5,324 removals of children in the juvenile court to defects? Is that number correct, sir?
I personally do not know, but I have no reason to question the lady's figures.
And isn't it true that currently there's a confusion over about the removals of about 25 of these children who are in the CHINS program? Is that correct, sir?
Again, I have no reason to doubt the gentlelady's numbers.
And this bill might relate to a dozen of those 5,324 removals. Is that correct?
Well, assuming your figures are correct, which I don't question, that would be true as of the cases pending today. We don't know about cases in the future.
Final question, does the gentleman yield?
Yes, ma'am.
Wouldn't it be helpful if we went back to our districts and talked to our juvenile court judges about how the Children in Need of Services program is really working and what we could do to help them prevent these 5,324 removals into defects?
I would concur, yes, ma'am.
Thank you.
Thank you for the questions.
Gentleman yield.
I yield, Mr. Speaker.
Representative Panich has a question to your left towards the back.
Does the gentleman yield?
Yes, ma'am.
I know that the juvenile court judges who appeared in our committee had some problems with this bill, and it went back to committee. It went back for further negotiations. Do you know if those issues have been resolved? Are the juvenile court judges on board with this bill?
I don't know that they're on board. I believe that a number of changes were made to address concerns they had with the language of the initial bill, which could have been interpreted in a way to require that a court not proceed until it had obtained certain information or provided certain notice, and I believe that has been addressed. I can't say it's to their satisfaction, but I believe reasonably those changes have been made to make it clear that the court has to consider these things on the record, but it doesn't necessarily have to stop the proceeding and go have files delivered. It just needs to make an inquiry and consider to the extent of the information it has.
Okay. Does the gentleman further yield?
Yes, ma'am.
So just to be clear, you don't have a sign-off from the juvenile court judges?
I'm not aware of such a sign-off, no, ma'am.
Okay. Thank you so much.
Thank you.
Gentleman has one more question.
Yes, Mr. Speaker.
Representative Jasmine Clark to your left has a question.
Thank you, Mr. Speaker. Does the gentleman yield?
Yes, ma'am.
So when these children in need of services, or as you refer to them, the delinquency cases, when they are taken into custody of DFACS, where do they go?
I think that's sort of a question beyond the scope of the bill, and I frankly don't know for sure, but I know they try to place them with family, then they place them with foster parents, and I believe there's been some news about other placements, but I don't have any personal knowledge of that.
Does the gentleman further yield?
Yes, ma'am.
So you might be alluding to what I'm going to ask next. Earlier this year, we saw a lot of articles about hoteling and the fact that a lot of these departments don't have anywhere to send these children, so they're putting them up in hotels. Would anything in this bill help or exacerbate that issue?
Well, to answer the latest question, I think part of the reason for the bill is to make sure that DFACS is aware and has an opportunity to be heard before a court places a child with DFACS. And I think some of the issues to which the lady is alluding have happened because DFACS isn't always made aware up front when the placement is going to happen. So I think it is the hope that this will allow DFACS to engage with the court, provide the court information, and help the court make a decision that might avoid placements that are less, sort of less satisfactory to all of us.
All right, so there's a gentleman further here for one last question.
Yes, ma'am, I will.
So is the goal of this to get less children in the custody of DFACS, or is it to get more children in the custody of DFACS?
I would say that I don't believe it has a stated goal of increasing or reducing placements. It has a stated goal of making sure that the placement we make is based on the best information available to the court at the time, and that it's the most appropriate placement for the child under the circumstances.
Thank you.
Thank you for the questions. Mr. Speaker, if there are no further questions, I'll yield the well and ask your favorable consideration of Senate Bill 133.
Gentlemen, has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to withdrawing the committee substitute? The chair hears none. The committee substitute is withdrawn. Is there any objection to adopting the substitute offered by the Committee on Rules? The chair hears none. The Rules Committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no. And the clerk will unlock the machine. Have all members voted? All members voted. If so, the clerk will lock the machine on the passage of the bill. The yeas were 102, the nays 69. The bill, having received the requisite constitutional majority, is therefore passed. Representative Washburn is recognized for a motion. Representative Washburn. Representative Dale Washburn, excuse me.
Mr. Speaker. I move that the House disagree to Senate substitute House Bill 514.
Mr. Clerk, will you read the caption?
House Bill 514 by Representative Washburn, the 144th and others to be titled an act to amend Chapter 66 and Title 36 of the Official Code of Georgia Annotated relating to zoning procedures so as to provide for the length and renewal of moratoriums related to zoning decisions.
Representative Washburn will explain his motion.
Thank you, Mr. Speaker. The Senate in committee amended our bill to add back multifamily when our bill had originally been to limit moratoriums on single-family dwellings. And also there was a floor amendment today that added some language about the waiving of impact fees on workforce housing. And that is the reason we are disagreeing, Mr. Speaker. Thank you.
On the gentleman's motion that the House disagree to the Senate substitute, is there objection? The chair hears none, and the House has disagreed to the Senate substitute to House Bill 514. Representative Brad Thomas is recognized for a motion.
Thank you, Mr. Speaker. I motion the House agree to Senate substitute to House Bill 374.
Clerk will read the caption.
House Bill 374 by Representative Thomas, the 21st to be entitled an act to amend Chapter 36 and Title 36 of the Official Code of Georgia Annotated relating to municipal annexation of territory.
Gentleman's recognized to explain the Senate substitute.
Thank you again, Mr. Speaker. This bill was amended in the Senate to provide further applicability restrictions to the alternative de-annexation process that I've presented to you all on crossover day. Additionally, it now includes a provision for homeowners and business owners to choose a fuel source they wish or need to use their appliances when, while still allowing local government authorities to enact voluntary efficiency or environmental programs. And it also provides for parity between the treatment of fuel sources powering leaf blowers.
The gentleman has no questions.
And I will gladly yield the well. Thank you, Mr. Speaker.
The gentleman has yielded the well. On the gentleman's motion that the House agree to the Senate substitute to House Bill 374. All those in favor will vote yes, those opposed will vote no, and the clerk will unlock the machines. Have all members voted? If so, the clerk will lock the machines. On the gentleman's motion, the yeas are 101, the nays are 66, and the House has agreed to the Senate substitute to House Bill 374. Members, we're going to adopt a group of privilege resolutions so they can be printed, and you can pick up the pretty copies before you head home. Will the clerk, will you read the caption to a group of privileged resolutions?
Honoring the life and memory of Mr. Tommy Dortch. Honoring the life and memory of Carmen Schultz. Recognizing and commending Mary Ann Mitchum for more than 15 years of extraordinary contributions and devotion to the betterment in the city of Hampton and Henry County. Recognizing and commending the J.C. Murphy High School class, 1973. Recognizing and commending the 2023 Heart of the Community Award recipient, Melissa Rutledge. Recognizing March 21st, 2023 as Mayor Donya L. Sarder Day. Congratulating and honoring Lithonia Chapter 3280 of AARP Incorporated. Commending David Yarbrough, Chattooga High School's 2023 Star Teacher. Commending Laura Bryant, Tryon High School's 2023 Star Teacher. And commending Jacob Travis, Modell High School's 2023 Star Teacher. And commending Laura Wyndham, Coosa High School's 2023 Star Teacher. And for other purposes, that completes the reading of the privilege resolutions.
Is there any objection to adopting the privilege resolutions? Chair has none, and the resolutions are adopted. Thank you, Mr. Clerk. Okay. I was waiting for a motion, but I didn't get it, so we'll move on. I gave y'all a chance. It's too late now. Members, we're going to do one procedural action. As soon as we break for our dinner hour and a little more, before we do that, there's a number of you have some great pages over here on the wall that have worked hard today, so don't forget to come up and get your photos. We'll be breaking in just a minute, and then we'll take page photos, and we'll go to our dinner break. That's our posture. For what purpose does Representative Panich rise?
I have a motion.
State your motion.
I move that the rules be temporarily suspended so that a resolution may be read for the first time and assigned to committee.
Clerk will read the caption.
Unnumbered House Resolution by Representative Panich of the 51st and Carson of the 46th, a resolution condemning Jew hatred in all forms and resolving to end the persecution and discrimination against the Jewish community.
On the lady's motion that the rules of the House be temporarily suspended so that a bill can be read for the first time and assigned to committee, is there objection? Rules. For what purpose does Representative Leverett rise?
Make a motion.
State your motion.
Mr. Speaker, I move the rules be temporarily suspended so a bill can be read for the first time and assigned to committee.
Mr. Clerk, will you read the caption?
Unnumbered House Bill by Representative Leverett of the 123rd to be entitled an act to amend Part 2 of Part 6 of Article 6 of Chapter 2 entitled 20, the Official Code of Georgia annotated relating to conditions of employment in elementary and secondary education.
On the gentleman's motion that the rules of the House be temporarily suspended so a bill can be read for the first time and assigned to committee, is there objection? Education. We have two announcements. Chairman Williamson is recognized for an announcement.
Thank you, Mr. Speaker. There'll be a short caucus meeting for the House Majority Republican Caucus in Capitol 341 upon a dinner adjournment.
Which room?
It's Appropriations Room.
341.
341.
Yes, thank you, Mr. Chairman. Chairman Mitchell is recognized for an announcement.
The Democratic Caucus will meet upon a break in 6:05 in the CLOB. Dinner will be served. Thank you, Mr. Speaker.
All right. That sounds like a deal. That completes our announcements. Page photos. This House will stand in recess until 7:30 p.m. 7:30.